Law School Secrets, Series 6. Welcome, glad you're here. As Gandhi says, be the change you wish to see in the world. Alright, so we're on 6. Now, I have to let you know that I found out that my other videos, the microphone was not working on them. I ran an audio test, and it turns out that my MacBook Pro is actually working better than the microphone that I had, and I'm going to redo all the these narrated criminal law videos, which is the start of the series. Now, I did A5, which I'm going to redo, but I was in the middle of the 6 when somebody had emailed me from another website where I have these loaded, and I upload on another site, and I have more followers on that site than I have on this site. But what I was going to do is I was going to keep building on each. I make a slight outline, and I start with the basics, and then I go through the outline and I detail each section of criminal law, because I'm going to have a separate series for each subject, and I'm starting with criminal law. Well, so I left 5. I redid 2. If you'll notice, I redid 2, and then I decided I'm just going to go ahead and I'm going to move on to the one that I was working on last, and then work backwards to redo them all, because otherwise there's going to be a delay in the series. So basically, criminal law is derived from common law in England. Some of the cases you're going to hear about are going to be from the English courts, and that is where we got our foundations for most of the United States. Louisiana, and I think there's a few other areas in the United States that use either French or Spanish law from the early colonization of the United States. Every state's different, of course, but so there's state statutes, and I believe I covered this on the other videos, but I'm reiterating some of it because sometimes somebody will just watch a video and then they'll not see the other ones. So anyway, here's the basics. The elements of a crime. Actus rea, that's the volitionary or voluntary act. Mens rea, intent, culpability. Concurrence, must be between actus rea and mens rea. Causation, actual but-for cause and legal proximate cause. There's entire chapters on that, and each of these segments, and of course you've got your criminal result or harm, and there are exceptions to this, where omissions to act are not part of the crime. And I discussed this in my earlier videos I did, so I'm picking up where I left off, but I will just briefly touch, and then you can pause it if you want to take notes, if you haven't seen the other ones. So again, this is from the last one. I went into detail over the different, the mens rea and culpability, general intent, specific intent. I discussed how MPC and the different laws apply, and discussed the strict liability. If you want to go back, I will redo the audios on the other ones, but for now I'm just trying to get through this so I don't take up too much time. You can pause it. There's a way you can also speed it up on YouTube. You just hit that little wheel, and a thing will come up and it'll have the speed on it, and you can pick twice as fast or 1.25, and you can speed up or slow down the video. So it's nice that way. YouTube has that. Also, there's another VLC media player you could put down that's free, that you can speed up your videos. Okay, so anyway, back to the subject at hand. Most state courts use general intent and specific intent to classify crimes. Criminal law analysis is based on a combination of statute or federal law, depending on which has jurisdiction, and then common law. So the courts look to the common law when the term in the code is not clear. An example, Keeler versus Superior Court in California was that the code, they looked at the code, they had this huge argument over this case because there was a pregnant woman and she was 9 months pregnant. Her husband accused her of having that baby from another man and saying it wasn't his baby and he's going to kill the baby. He deliberately kicked her in the stomach repeatedly, and I think I heard it was on the side of the road. I can't remember. It was I read this case over a year ago, but I still remember it because it really, it got me upset when I read it. And I reread it before I did this video, and I was like, well, wait a minute. I looked and I noticed that the law had changed. When we were in class, they just told us to read the case, brief it, and we didn't even discuss it that long. But they never said, oh, by the way, the law changed. They just talked about how the baby was not considered a human being in the definition of the code and causation and intent and all that. But the thing is, if you look at the law, one of the lessons I learned from it is it's a perfect application of ex post facto definition. The law did change, and the code now says human being, so you can't charge him with it because it's an ex post facto case. Now, mens rea, to continue, we went over this before. If you recall, there was a bigamy case. A wife, this is, by the way, this is English law. There was a case where a woman got married and she had a husband, and he disappeared, like, I think it was like less than a year into the marriage. And, or just about a year after the marriage. And he's gone. She meets somebody else. Somebody in between tells her, hey, your husband went off on a ship and we think the ship wrecked and he's dead. And so she mourned the loss of him. She had no way to bury him or anything. But another gentleman met her and he courted her and they got married. Well, he shows up and he's like, wait a minute, you're my wife. And let's get her arrested for bigamy. So basically, she got convicted of bigamy and appealed. And on appeal, they did, the judge wrote a really long, considerate thing on mens rea, intent. And he basically was like, look, there's no single mens rea. And he did overturn it and everything, but basically there's a lot of details in that case, the original opinion, that would help you understand mens rea. But if you look at some of the older treatises like Wharton or others, you can also read in the Horn books on that. Now, Morissette versus United States was a federal case. A guy was on federal lands, and he was a nice avid outdoorsman. He saw heaps of metal on there, and he thought, hey, I can get some money for that garbage. And he sold it to a scrap metal dealer, and he was subsequently arrested for theft. And he was charged with stealing government property. And he said he didn't have intent, and the judge looked to the law, and it didn't say anything about intent in the law. And this man did not have intent, and the conviction was overturned because he didn't wrongfully take it. He took it because he thought it was abandoned property. It was like scrap metal. So with the federal courts, that illustrates the mens rea. And this culpability or mental state will be argued in court if it gets to court. And you're also going to get it in analysis, in essays, or in multiple choice. And you might say, well, when you get these hypotheticals, you need to think like a lawyer and answer like a lawyer. Now, there's not always agreement among attorneys, but there's general consensus on certain issues, and if you analyze it logically and you know the different rules, you'll be able to answer with a high probability of being correct. So we discussed this earlier. You can pause it if you want to read it. And we also discussed this in an earlier video. I went through each of the MPC descriptions, or how it is interpreted or understood. And I also discussed these cases as examples of what they mean by it. And if you look at the earlier videos, you can go more in detail on it. But this is the kind of stuff you want to put, you'd probably want to put in your outline just a general statement of what it means, but you don't have to put all these details, but you need to understand what it means. So the mens rea of attempts, MPC 501, points are that the defendant purposely took a substantial step or through purposeful omission for a result planned to culminate in a crime, requires acts rea plus mens rea. And MPC defense is renunciation of the crime. So remember before, MPC generally rejects general intent and specific intent, but they do have a different way they handle the attempts, criminal attempts. Okay, transferred intent. Now, I went over this in another video in detail, and it is an important concept to understand, and I discussed the cases. I'm just reviewing right now. I'm showing you what I did before. And remember, it's always a balancing act. Now, there was a case, Regina versus Smith, in England as well. And I did discuss this briefly. I added some pictures in this time, though. And I've discussed this before, other elements and details. Now, this I didn't go into too much in 5, so I'm going to read this to you. Motive in a criminal law is that which tempts the mind to indulge in a criminal act. Sandy versus State, a case in Wyoming. You might want to look that up. You can look in your horn book or a commercial outline or something, or read up on it, but motive must be distinguished from intent. It's a separate thing. It's an underlying condition or a contextual compulsion. It can be visceral, negative, emotional, or immoral, unrestrained impulses of greed, vengeance, bigotry, racism, sadistic domination, lust, gluttony, and jealousy. Emotion that compels can be ruled by the primitive brain and not by the reasoning brain. This portion of the brain overrides logic to a degree. Proof of motive is not an essential element of a crime. Rather, motive comes up to illustrate how corrupt the defendant is or is not. In other words, in the art of arguing a case, or even when you're reading a case, they will use emotion to argue. But law is based on logic and weighing fairness and meting out justice. We're going to look at all kinds of elements, but if you look in the Horn books, you will see that motive is not required. It's something discussed, though, and you need to distinguish it from intent. Now, concurrence is required in a crime, as we mentioned earlier. And to be guilty of a certain type of crime, you're going to need to read everything step by step. Because when a prosecutor charges someone with a crime, they get indicted, they get charged, that's for criminal procedure, but they have to charge them with the right crime. Now, you will be given a hypothetical. You will see a situation. Don't let your emotions get in the way. Here's an example. John works in a jewelry store, and he is an assistant, and he repairs jewelry. He sees he's got this piece of jewelry. It's very expensive. He's got a little case. He fixes it. Somebody comes in the shop. He gets interrupted. They'll give you a fact pattern. It's kind of long. I kind of made this up. And so he slips it in his pocket because he's interrupted, and he's like, oh, I gotta go. He forgets about it. He gets home. He takes the box out. He puts it on his dresser. His wife sees it, and she's like, oh, you remembered our anniversary. Oh, it's beautiful. Now, Joe doesn't have the heart to tell her that he accidentally took this piece of jewelry he repaired home. And you'll be asked in the fact pattern, did he commit larceny? And you're like, well, he took it. Well, you got to go through and break down the elements, and you have to decide if that's what he did specifically. And, of course, the answer would be no. He did not commit larceny. He might have committed another crime, but he didn't commit larceny. Well, you've got to know what that crime was. And so does the prosecutor. Because if the prosecutor brought a charge against him for larceny, he would lose. He has to use a reasonable charge based on what he knows. And if this guy keeps saying, hey, I didn't steal it, and, I don't know. It's hard to say, but anyway, so this is the idea of concurring. The act of stealing has to be at the time. You have to form the intent in your mind. You have to say, hey, I'm going to steal it now. So, the attendant circumstances require concurrence. Strict liability, of course, is an exception to that. Now, causation is often applied in destructive crimes. It's most often spoken of with respect to homicides, but it's also with mayhem, arson, malicious mischief. And prosecutors need to prove both factual and legal causation. And a causation has a two-part test: the but-for or factual cause, and the proximate or legal cause. Now, the MPC analysis only uses the legal cause or the proximate cause test to establish causation. And another caveat here is that criminal law causation is similar to, but not the same, in application to torts. Criminal law is going to have a higher burden of proof. Now, vicarious liability is the concept of being held liable for a crime that you did not commit, but you were somehow involved in. And U.S. versus Arthur Anderson is an accountant for Enron. Evidently, he and his company were charged with the crimes in the scandal, and they destroyed a bunch of documents, so it was hard for them to get evidence. They shredded papers. Now, he was found vicariously liable, and he did appeal. Now, I had first learned about this in school, and it was used as a vicarious liability example, but before I wrote this and discussed it, I looked it up again just to brief myself quickly, and lo and behold, the law has changed because he appealed, and on appeals, it was overturned. So, there you go with your vicarious liability. Now, Pinkerton's rule is a type of vicarious liability, and this is an oldie but goodie. In Pinkerton versus United States, it became common law. It set a precedent that all conspirators or each co-conspirator during the crime will be held criminally liable for each and every crime that is reasonably foreseeable in furtherance of the crime of the conspiracy. Now, you need to memorize just maybe the little light green part, if you're not, and memorize that for your essays, and because that might come up in some of the hypotheticals on UBEs or MBEs or in multiple choice. It's fair game. But anyway, now the MPC does argue that Pinkerton's too broad and it narrows the scope of liability based upon specific roles such as solicitation, aiding, agreeing, and attempting to aid. And it's ironic since they reject specific intent and general intent. So you're going to see a lot of almost like semantics or arguing over words. And there's so you almost have like a trifecta here. You've got common law, you've got statutes, you've got MPC, you've got federal laws, and, things can be thrown out on technicalities. The prosecutor has to get it right. There's the rule of leniency. I think I talked about that in the second video. But here is your outer outline, and I want you to continue to ponder these, and please, by all means, make sure that you know the basics, because you can lose points on questions or not understand why you missed the question because you're missing an element or a step. And I went over this before, but I want to thank you for being here, for spending time listening to this and learning, and I appreciate all your likes, and please subscribe. And here are the references as usual and my qualifications. Again, thank you so much. Have a wonderful day and hope you get A+. Thanks for listening.